We are joined by WAIKWA. He is a constitutional lawyer. He has participated in Supreme Court proceedings with regards to presidential petition. He joins us via video link from the UK. Good morning, WAIKWA.
Good morning, Eric.
Good to have you on the show. Once again, always a pleasure having you in the Situation Room. How's the UK?
The UK is fine.
Great. Now, WAIKWA, you know that today is a big day in terms of waiting to see the number of parties that go to the Supreme Court to file a petition with regards to the presidential election. Looking from what we saw in 2013 and 2017, what is it that would take somebody to the Supreme Court?
Jane, thank you for having. So just to start with the Constitution. That the Constitution says once you have a declaration of a president-elect, then anybody who has concerns about the validity of the election can challenge that election at the Supreme Court. And the Constitution talks about essentially everybody. So a voter can do that, not just a presidential candidate. And we've seen in the past voters do that. In fact, the petitions have been directly involved in, have related to voters, not presidential candidates. Although when the matters come to court, obviously they get consolidated. And then it's the courts that then have to make a call within the 14 days that you've talked about. But Eric, I think it's important for people to have the context in history. The context in history is that in 2007, following the 2007 elections and all the fracas and violence that ensued, and then when a commission was specifically set up, that's the Kriegler Commission. The Kriegler Commission was specifically dealing with electoral injustice. One of the issues that came up was the question about the confidence that Kenyans had in relation to court. As you remember, Raila Odinga had failed or had refused to go to court. And it's on that basis, and obviously the discussions that had been had while drafting the Constitution, even at Bomas, that the Supreme Court was given these mandate. The 14 days specifically are meant to make sure that the issue relating to validity of a president-elect is resolved very quickly so that the country can either go back to a fresh election or can move on with the new president-elect who is sworn in.
Okay. I mean, even taking into consideration the history, WAIKWA, and saying that, look, from where we have come and now this is where the country is at this moment, then going to the Supreme Court today, are we looking at very different issues from what history has previously told us? This is not the first time. 2017 could easily have been the first time probably in the world that such a thing had happened in terms of the decision that was then made by the Supreme Court. Thereafter, we saw certain things then having been set as precedent. We also saw thereafter that then there were changes as dictated then by court that then influenced the manner in which elections would be carried out this year, notably being the transmission of results from tallying centers, right? Are we looking at different issues then going into the next 14 days? Are we looking at different issues, or are we saying more or less we'll have a repetition of what happened in 2017, details of which you were privy to?
I'm not sure we're looking at different issues. There's one issue I think that come up based on public comments made both by candidates, their supporters, and also knowing what happened former. But just to go with the traditional issue, you expect that there will be contest about numbers, and the contest about numbers, I think, will be at two levels. The first contest will be whether the numbers add up. There has already been significant public conversation about that. The second is whether in fact the margin, whether you look at the absolute margin, which is, I understand, over 200, just over 200,000. That is the margin between William Ruto and Raila Odinga. Or look at the margin that we have lost up, which I am again is just about 66,000. Whether any of those margins, when you look at the numbers, they add up, and each has different implication. If the court or if that issue is raised, then the court goes there. But you can almost certainly know there will be a contest on numbers. The second issue, especially that the 2013 petition was a lot about numbers. The 2017 petition changed the tone a bit by adding significant aspects of technology and verifiability of technology. And you can anticipate, especially given the experiences of 2013 and given some of the comments again made by candidates and their supporters and some of what we believe are their lawyers, also the issue of technology will come up, and whether that is the failure, some of the reported failure in terms of Kim's kit, whether it's the procurement of technology, which has already been litigated to some extent, but also has been a bit discussed, or whether, in fact, as in 2017 rather, there was interference with technology, especially after the transition. Remember, our election is not, we don't do an electronic voting, but we use technology for voting. And the technology is used at the identification stage, registration, identification, and then transmission, but the voting itself is manual. So any part of that, three parts where technology is used can come up. But we also saw some issues come up, including the sensational issue relating to Venezuelan that also touched maybe to some extent on technology. I say there might be one different issue this time, and that is the issue about the commission and who has what powers in the commission. Again, remember the four commissioners who seem to have disagreed with Chebukati. The main question they seem to have raised is who has the powers within the commission to declare, to tally, verify, and declare the results. It seems like their contention, going by the public statements they issued, that they were involved in some of the tallying, they were involved in some of the verification, and towards the tail end, they seem to be claiming that that is when they were not involved. And they're saying that that decision, all the function of tallying and verifying, including declaration, the final declaration, is something they have to be involved in. And in fact, it seems to me that they are suggesting that they have to vote on, and if they are the majority on some of those issues, then the chair is supposed to go by the majority. So that is going to be the issue. I think that will be distinct, likely to be mostly distinct in this election. I think the other issues will be relatively the same issues that have been raised, of course, based on new, different evidence and maybe a little bit of tweaking.
WAIKWA, if I can ask you, everybody seems to say, I think the opening statements from anybody, whether you're making a statement on social media over the last 1 week or so, is the first thing that everybody says, the law is clear. So is it really clear then? And even before things get within the four walls of, any court today, what exactly is it? Everybody says the law is clear, that, the chairperson of the commission can go ahead and declare with or without consensus Then the other side says there must be corporate consensus. The decision comes after, everybody sat and made their own deliberations, and then we say go ahead. What is it? And I think that's very clear that everybody wants to know, what is it?
The law is not clear. Maybe I'm the first one to say this. The law is not clear. On this issue, actually, it's a very, very complex issue. And I think actually when listening to both sides, both the chair's version and listening to the commissioners, I think both sides actually, and based on my own analysis of the Constitution and the electoral law, but also based on the previous practice. Remember, practice also matters in 2013 and 2017. And in 2017, you had 2 elections. And the 2 elections differed in approach. Then you realize it's not clear. And additionally, in 2017, there was the case of Maina Kiai, which will become, I think, center stage in this contestation, at least on this issue, because it adds to some of, in fact, it goes to the heart of what happened at Bomas and who should be doing what. Why do I say the law is not clear? So the contestation is whether, just to put it very simply, in terms, when the Constitution in Article 130, I think it's Article 133, says it's the Commission obligation to tally, verify, and declare results. And then when you go to Article 130, Article 10, it says, it talks about the chairman having the responsibility to declare the results. Is there a contradiction there, right? Because you jump from the commission in 133, and then you come to 10, and then for declaration specifically, it talks about the chair. So is there a distinction? But let's go back a bit. Something that seems to have to be missed by the 4 commissioners, but also haven't seen elaborated even by the chair. Who is the commission? Who is the commission? Is the commission the 6 commissioners and the chairperson? What about the secretariat? Is the secretariat the commission? Mm-hmm. And so when we talk about tallying and verification, is that responsibility on the commissioner, or is it on the secretariat, or is it on the chair, or is it on the corporate body, including secretariat and the commissioners, or just the sort of what you would call the body of
the institution.
Yes, so the lack of clarity. Remember, pragmatically, commissioners don't tally numbers.
Yeah,
it's the secretary that tallies numbers. We are talking about over 46,000 polling stations, and then you have to do those tallies. It's not the commissioners. Commissioners may be there to look at how the numbers are being tallied, which is probably partly verification. But even the verification, some of the verification is being conducted by the secretariat. And so what do you do? People need to go and look at the history of 2017. After the Supreme Court nullified the election, what happened? Remember, there was a statement by Wafula Chebukati, and there are questions, for example, whether certain senior officers of the commission were involved in the second election, including the then CEO. So you ask, how do you resolve that? And then finally, when you say, for example, you say the commission, there are questions about majority and whether, for example, the chair is going by the majority. What is it? What are we talking about there, and which decision are we talking about? For example, I can ask a rhetorical question.
Mm-hmm.
If the two sides they are split 3-4. We will always likely have a 3-4 split whenever we have 7 commissioners, which now seems to be the tradition. In fact, 2017, at some point, there were questions about how the commission was split. If one side, if the numbers add up to one thing, the majority, and this time assume the majority includes the chair, decides the numbers should have added to another thing, which and there is a vote taken by the 7 commissioners. What does that mean? And so what does it mean for the actual numbers representing how the voters voted?
Yeah.
And what is the chair, who is supposed to finally declare, supposed to do? And then let's go back to Magna Carta, very, very basic. Magna Carta says, and this is the most important thing about Magna Carta case, is that the results at the polling station are final. So then the question becomes, what are the commissioners and the commission doing when it's verified at Bomas? If the results at the polling station are final, and what are they supposed to do when, for example, they find discrepancies in the process of verification? And so that will come up. And so if they find significant discrepancies, for example, which could alter the outcome, either because it could bring about a runoff or because it could substitute who initially had the numbers and was thought to be president-elect to another person, what do you do and get the results at the polling station are final? So you see why, for me, I say the law is not clear on this, and it will take actually very significant guidance by the Supreme Court on what should have happened. And in my own view, I don't want to go into this. I think both sides are missing out on something. I don't think either side is.
We have many more questions to ask you, WAIKWA, but let's take a break at this point because we'd like to understand what's been happening in the last 7 days. If you were to put yourself in the shoes of those who are preparing to go ahead with this petition, from the Azimio side, from the IEBC side, from the Kenya Kwanza side, what is it that they need to prepare before they go to court? How do they organize themselves? Do they need to have leaders? Do they need to have very many other teams? The few lawyers that we say speaking in the Supreme Court, are they the only ones who are involved in preparing for the petition? All these intrigues and intricacies are part of what we'd like to understand. WAIKWA Wanyoike is a constitutional lawyer. He is one of the lawyers who participated in previous presidential election petitions in the Supreme Court. He's taking us through the thinking behind the teams and also taking us through the understanding what exactly happens in a presidential petition. 29 minutes after 8. This is Kenya's biggest conversation, The Situation Room. We're live on SpiceFM, on KTN Home, and online. Let's take a look at the weather and traffic. We'll be back shortly.
This is The Situation Room, the only way to start your day.
We're looking ahead into the 2022 petition at the Supreme Court. So, WAIKWA, looking at, let's say, the Azimio la Umoja One Kenya coalition, which has indicated that they are going to file a petition at the Supreme Court over this, when do you think they made the decision, and when did they start preparing for this petition?
When did they make the decision? I assume right after they got the result, although in fact there is a possibility that they could have, given the trend, seeing how the results were coming in, they could have made that decision slightly earlier. But in fact, that doesn't say everything, because one of the things I would assume that every presidential team, as part of the logistical team, when presidential teams are being formed during campaigns, one of the things that a presidential candidate has to always think about, and especially the consequential or the leading presidential candidate, is that there is likely going to be a challenge at the Supreme Court following the results. And any diligent presidential candidate would start putting together a legal team. So we are talking about legal teams having been probably been created a year ago. Some of these candidates have advantage because they've done this previously, and they already have individuals they go to and who already know the trend, have participated. So it may take less time to bring them up to speed, but some candidates may not have that advantage. So the preparation in terms of putting together the team has to start fairly early, and then they have to assume to prepare on two possibilities. One, the possibility that you will be the petitioner, and so what do you need as a petitioner? Or you'll have to defend the petition if you are the one declared president-elect, and you can almost expect that both camps may anticipated that they could be on either side, just given how the campaigns were going. And so the preparation is slightly different when you're thinking about preparing to launch the petition or preparing to defend a petition. But you have to anticipate that and to put together not just the human, but other logistical arrangements in place.
Sounds to me like they both prepare for both eventualities, which means that they both know what they'd like to raise in the Supreme Court, which would be, of course, painting the IEBC as having bungled the election, or on the other hand, showing that the IEBC did not bungle the election, which means that they could already see where the loopholes would be in the run-up to the election.
Of course. And Eric, IBC is the other party, and IBC will always be a party, whether the claim is brought by WAIKWA or just your regular voter. So if there is one common denominator that has to be prepared ahead of time, is IBC, and you can be sure also IBC has been preparing for quite a long time. They knew at least some of their lawyers, especially the lawyers who do a lot of heavy lifting, which is what most of the time the public doesn't see. The public gets to see the celebrity lawyers, the big names, the ones who show up in court and present. And most of those big name lawyers are actually coming to the game very, very late. A lot of them are procured after the results are announced. There are the little team that actually works on the case is a team of maybe lawyers who are not very, very prominent and who would have started the work, and especially for IBC, long time. Let me say this, and this is where I should have started. Preparing for a presidential election petition, whether you are preparing to bring the petition or to defend the petition, but more so to bring the petition, is such a Herculean task. It's a Herculean task for a number of reasons. The first is because of the number of days that we talked about earlier. The time is so short, and the amount of work that one has to do is so much that if you don't have your all your ducks in a row, even before the declaration of the results, you'll fall behind. And this is why you see parties would want to file earlier. In fact, sometimes parties will give statements indicating we'll file 2 days before the deadline, but they count down to the wire. And this time round, the time has been reduced somewhat. In the last two elections, the Supreme Court accepted filing up to midnight of the last day. This time, they are only accepting filing until 2 p.m. And I can almost certainly tell you, for most of the parties who are contemplating filing, or individuals filing the petition, most of them will be scrambling up to the last minute just because of the amount of work. Why? And again, for your listeners, Eric, we have to understand when you go to Supreme Court to try and question the validity of an election, you have two pathways. The first thing a lawyer does is to develop what we call case theory. What is it that you're going to be telling the Supreme Court to convince it that the election was not validly conducted? Some of the issues we talked about earlier, those are formulated as the case theory. But what a case theory does is to put you on one of two tracks. Are you going to do an evidence-heavy petition, or are you going to do mostly a legal issue petition? Let me give you an illustration. If you go to 2013 presidential petition, there were those two kind of petition. The petition that Raila Odinga brought in 2013 and some members of civil society led by Gladwell Otieno, those were evidence-heavy petition. They are questioning about numbers, tally. They are including almost, you find 20,000 forms included as part of evidence. So those are evidence-heavy petition. The 2017 Raila Odinga petition and the later petition that was filed after the rerun by the civil society, which is the petition I directed, those were evidence-heavy petition. However, in 2013, if you go back, there was a petition that was brought that was not evidence-based petition, and that was a petition brought by Moses Kuria, Itumbi, and a lady called Gematio. And that petition just asked one question. In calculating the 50 plus 1 vote, do you base that calculation on all votes cast or only valid votes? In that case, if you are the petitioner, you're not filing much evidence. Beyond filing the Form 30, what now is Form 34C on the total number and how the commission calculated its percentage, you don't need to file much. But when you are filing an evidence-heavy petition, and especially because the Supreme Court uses a relatively high standard in requiring somebody to be able to show enough to invalidate the election, then you have to file a lot of evidence. And we can go through the type of evidence that is needed on either issue. But that brings me to just the capacity you need in terms of personnel. First, you need lawyers. Any team, especially the presidential team, I doubt that any of them has less than 20, 30 lawyers working on this petition, which is not a small, just even coordinating that number of lawyers is not an easy feat. At one given time when we were preparing for our petition in 2017, sometimes I would count 80 people in the room running around, not all lawyers, of course, because you have to have people who are photocopying. We at one point you have maybe, and ours was not necessarily the grandest production, but you have like 4 photocopiers running 24 hours, 80 pages per minute, and you have people manning those, organizing documents. You have people reading documents. Supreme Court has weird rules. For example, it says every document filed at the Supreme Court has to be each bound. You can't just bind anyhowly. Every document that is filed by the Supreme Court has to be, you have to show every 10th line, and so people have to mark each page where every 10th line is. So things like that. And so it takes so much energy to be able to put everything together. And you're talking about tens of thousands of pages. When you think about just Form 34, I think it's over 600 pages, if I'm not mistaken. You have to produce 8 copies for the court, mostly in big paper because of the legibility. And then you have to produce maybe another 20 copies because at the end of the day, you end up maybe with 20 parties. It's a very, very big production. So I can tell you, anybody involved in this petition most likely have had any sleep in the last, or more than the last 7 years.
WAIKWA, let me ask you this question. I'm looking at our electoral processes, and it looks like we have begun a tradition of always going to the Supreme Court. It's like an inevitability. We will end up at the Supreme Court. What would you say needs to happen with our processes so that it becomes a rarity, that people only go to the Supreme Court on that rare occasion as opposed to expecting it to be the norm?
CT, I don't know whether we'll fully get rid of the Supreme Court, but I hear you, and we won't, because elections are such heavy fought contest, and sometimes becomes very, very personal. The stakes are so high, and of course the presidential petition, the stakes are even higher, and because under the Constitution, also, it's not just the presidential candidate who can bring petitions. Citizens can do that. Then it's very hard to anticipate that it's going to be soon before you see Supreme Court not having election petition. What might happen over time, and I think it's going to happen, and maybe relatively quickly, is you might see us getting into the tradition of less and less petition brought by the candidates themselves, and that means something for the court. Usually, it's less pressure for the court, although not always. And the reason I say that is, for example, if over time we are able to deal with the problems that we've had with IBC, which have been consistent, the fallout between commissioners, accusations about some commissioners siding with one side or another, and those suspicion, questions about the Secretariat and whether some of the staff of the Secretariat are being used by candidates and political parties to interfere with elections. As long as those issues persist, you will always then you can expect that as long as the people still have questions about the independence of the Electoral Commission, there will always be questions brought on the validity of the presidential election. But again, and I'm not sure we have enough evidence on this. Even for other elections, we've had very many petitions, election petitions, even in other positions, the members of parliament, governors, and MCAs. But I think the record is starting to show that there are less and less petitions there. This time round, we've seen people concede quite quickly. I think people are starting to realize that unless you have very good grounds, you just don't land to court. And I'm hoping over time that will also happen with presidential petition. I also think it might change depending on who the candidates are and what those candidates are seen to represent. So there are quite a number of factors that might help change that tradition, but it's going to take a while. I wouldn't call it for the next 2 or 3 cycles of our elections. I think we still have
conceding an election, WAIKWA. Can you unconcede? I mean, what is the legal position once somebody has conceded? Is it cast in concrete, or can they turn around and say, I wasn't sleeping well that day? So my thoughts on this subject, now that I'm wide awake, I am thinking this.
The court doesn't, there is no legal concept of conceding in an election that takes away candidates or voters' right to bring a petition. So the fact that we saw quite a number of losers in the members of parliament and governors' position conceding doesn't mean those people can't bring petitions anyway, even though they are public statements on that. Of course, their public statements, good lawyers are able to use those public statements as evidence to some extent, but that by itself is not sufficient. A candidate or even a voter cannot bring a petition when concession has happened.
Okay. WAIKWA, this is also something that has played out already in the court of public opinion over the last, 1 week or so. There are opinions that are, going up and about. Many have said that the Supreme Court then must take into consideration the politics of the day, and that many have said that this judgment will be a political one. We've said, all right, how do we then know what the court is going to say? However, question is, does the court or do judgments take into consideration the political pulse of the country at the time, or is it going to be purely, evidentiary to say that, look, this is what we have before us. We are going to judge on what has been brought before us and not on the politics and the emotion of the day?
So, if you ask a judge that question, they will tell you, of course, judges don't take into account the politics of the day. All judges do is to take into account the facts, the evidence, and the law. That would be the standard response you would get from a judge. But that's not always true. The fact is, cases, especially high-stake cases like a presidential petition, is not fully immune to the politics of the day. However, the way the court goes about it is slightly different from how the public tends to debate it. What the court is likely to do, sometimes it's verbalized, sometimes it's not verbalized by the judges, is by looking at the implication. So the court, for example, looks at what the facts are, what the law says, and then a judge must, and a good judge must ask themselves, if I decide this way, what are the likely implications? And are those implications proportionate? And so, to give you an example, if you go by the standards that the courts have articulated, if there is substantial violation of the law in elections or the Constitution, that is sufficient to invalidate an election. And in most cases, judges will invalidate the election if they find substantial violation. But then, what is substantial violation? And how does a judge assess this is substantial and it justifies, or it justifies nullifying an election? So, for example, a Supreme Court judge may not say it, but how much, for example, does a new election likely going to cost? And what is the likelihood that every box on legality will be ticked? And what are the violations on the law, or what are the irregularities? And the judges, and especially the unverbalized parts, have to think about what might be the overall implication if we nullify, both in terms of, for example, issues to do with the functioning of the country, whether it's in the economy, but also more importantly for judges on the rule of law. So it's a very, very delicate balancing act. And my answer is, it's not just the law, it's not just the fact. Judges have to think about the implication of their decision in context of the space they are operating in. And judges live with us. They are there, they are seeing what is happening, they are listening. Of course, a lot of that may be subjective, but that will play out one way or the other in their decision.
In 2013, one of the things that was a hallmark of the Dr. William Mutunga-led Supreme Court was something that had to do with evidence that was disallowed, or at least was presented and then disallowed. I'm asking, what then is the threshold for either allowing or disallowing evidence? So
there are different thresholds, but the 2013 threshold was mostly based on time. And time is really critical at the Supreme Court. And I think to some extent, both the court and the lawyers have rectified the mistake of 2013. The court has rectified the mistake of 2013 by being very, very clear on when different things have to be done by. In fact, the code circulated, I think, a few weeks ago, a very reader-friendly schedule on what happens on each day of the 14 days. And so in that way, then the lawyers now understand if you don't get something in by this day, you can almost not expect the court will accommodate you. And the court, to some extent, has to do that because the 14 days is not a long time. And in actual fact, the court only has about 7 to 8 days to fully deal with this, because the 14 days starts counting from tomorrow, because the last filing day is today. But then the court doesn't have the entire record until almost the 7th day from tomorrow, when parties, the respondents, have filed. So the time is a big threshold. The argument in 2013 was you don't just look at time, because time is a technicality. You also look at the probative or the nature of the evidence to see whether it's bringing something so significant that you have to admit it. Otherwise, if you fail to admit it, is an injustice. You also look at why did the parties not have the evidence in good time, and why are they producing it late? Sometimes it could be the failing by IBC, for example, and I'm not saying in 2013 that was the case. So the court has to balance those issues. But I can almost tell you certainty. It's if any party is filing anything late in this election, it's likely, or in a presidential petition rather, it's likely not going to be admitted. And it gets even more complicated when you have more than one presidential petition, because the court has to process, even if 100 petitions are filed, it has to process all those 100 petitions within 14 days. So it's reasonable for the court to be very, very firm. And it's also unfair to the parties, because the parties are around to file evidence later than when the court expects them to file. It's also a very onerous task on the parties who have to respond to be able to deal with that evidence. And a lot of the time, you have to go to the field to be able to find evidence to respond to what has been done.
Finally then, WAIKWA, where do you stand? What's your stand on the issue of the 14 days? Is it sufficient time to deal with a presidential petition, or is it not?
You know, Eric, and I've debated this, including in some of the colloquium with judges. I am still not 100% convinced that we need more than 14 days, and for a number of reasons. You have to take everything into context. This is the context. When you're talking about 14 days, we're actually talking about 21 days from the day the declaration was made, right? And then the likelihood, for example, and going to go back to 2017, if there is nullification, a new cycle is started. If you have so much, you could have paralysis for over a year, especially if the time is so long.
Yeah.
And remember, as long as people are waiting for the resolution of who is validly elected, that has significant consequences on the ability of the people to focus, and it has consequences on the economy as well as cultural activity. And the second reason is we've seen cases come to High Court, of course not with the same level of evidence, not the same level of intensity, and judges have actually dealt with those cases, and talking about a lot of them within a very short time. So at the end of the day, I think, yes, maybe something like 21 days might be a bit more acceptable to the and to everybody else, but there will never be a max number of days. And I think it comes down more to case management and the court becoming more in terms of enforcing its rules, especially on parties, and how counsel is. and I think the court is it did very well in 2017. I expect to see them efficient in 2022. So I wouldn't. I'm not too bored
on that. WAIKWA, thank you very much. Thank you. WAIKWA Onyoike is a constitutional lawyer. He's been talking to us about this presidential petition and what we expect to see. Keep it here for more conversations.
This is the Situation Room, the only way to start your day.